dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And you're back on Liberty Nation Radio, heard coast to coast on the Radio America Network. I remain your host, Mark Angelides, and we're continuing our long-form conversation with Scott Cosenza, Esquire, Liberty Nation's legal affairs editor. Thanks for sticking around, Scott. So,
my pleasure.
We've got to face it. It's almost October.
To face it, Mark, not got to face it. Get to face it. The new term.
Get to face it. What is this? Is this something?
The new term of the United States Supreme Court. The October term. Yeah, it's the new season.
It's a new season?
Pitchers and catchers report for those baseball maniacs, or spring training for football.
So we've not got any new players on the court this term, but we do have new cases, and we have quite a chunky emergency docket taking place. What are you looking forward to the most in the coming court term, Scott?
Okay, well, so maybe we should explain the merits docket versus the emergency docket, since you brought it up, which is sure. Merits claims are cases that bubble up from the lower courts. There's a dispute. My local county government says I have to pay $100 fine if I don't put my trash out on Tuesday night, and I don't do it. And I say it's my constitutional right to put it out whenever I like. I sue. It goes through the district court or the state court, district court, appellate court. And then if they choose to take the case to the Supreme Court, that's a merits docket. The emergency docket is, and we've seen so much of it with Trump, that's what we get is there's a district court ruling, and this isn't where they all go, but just for instance, it imposes a nationwide injunction on the Trump administration from enacting some rule, and then they run to the appellate courts who say, leave the district court order in place while we fight it out, and then the Supreme Court may say, okay, district court, you cannot enforce the ban on this while it's being fought out. And those are the kind of things, or the opposite, and having that challenged. That's the emergency docket. It's the merits docket, though, that I think we're going to talk about the most, and there's a few interesting cases. One case involves a Bible Belt state attorney general going after the donors of a pro-abortion group to try to attack them. Oh, no, wait. I'm sorry, Mark. I got the facts wrong on that.
Of course.
Instead,
it's coming a mile off.
Instead, it's a progressive attorney general who is attacking an anti-abortion group in New Jersey and trying to get their donor lists, which that had been decided. Actually, I don't have the site in front of me. I'm sorry, but I think it was in the 30s, but in a famous landmark case where it was in the South, and it was people trying to get the NAACP donor list, which you might imagine is a great imposition on free speech. And the New Jersey authorities are notoriously hostile to those who exhibit anti-abortion messaging. And that case is First Choice Women's Resource Center v. Plotkin. So
and
I'll definitely be...
what's the question before the court on that?
Well, the question is whether the Attorney General's discovery demands are within the bounds of the Constitution or without, or they violate the free speech rights of those who give money to First Choice Women's Resource Center v. Plotkin. He doesn't like their messaging. Mm-hmm. It was effective. And, the claim is that it was, I think, misleading. But these attorney general investigations that are political are notoriously awful, and on both sides. The attorneys general have almost, their power. Unchecked is maybe a bit rich, but boy, it seems like it's close to that.
It's a broad sweep. Yeah, I think that is an interesting case, that one, because, and this should be shouted from the rooftop, that what you do with your money is a form of expression, and therefore, protected under the First Amendment. What you do with your, let's not put that as a wide. There are many things you can do with your money that are not protected by the Constitution, but in terms
of paying for speech, though,
yes,
is hey, if you paid for libelous or slanderous speech, you would be liable for it.
Sure,
So why wouldn't you be? Why wouldn't you be entitled to the protections from free speech if you're paying for protected free speech? And the other thing is, we can't pretend that there isn't this political reason behind it. It is sought for. It'd be one thing if it was the imposition. The court often, and now maybe we'll see a revisit of this in the wake of what's happened with the global pandemic that we just went through. But if there's a medical reason, maybe you get a more of an imposition rather than the nakedly, infringing on people's free speech rights reason. So we will track it.
It's a very exciting case. What else are you looking out for?
Okay, well, the trans youth cases in sports continue. You wonder sometimes about how many years we're going to be, sorting through these issues. But it's a West Virginia case, and it involves somebody who is a trans woman who wishes to compete against biological women in, I think, track and field or cross country. The case got to the Supreme Court to answer two questions. It's the same question with respect to both laws. One is the Civil Rights Act of Title IX. Title IX of the Civil Rights Act of
1964. Yeah,
of 64, and the second one is whether the Equal Protection Clause of our Constitution, 14th Amendment, prohibits West Virginia or allows West Virginia to delineate youth government, school, sport participation based on biological sex determined at birth. That is the question presented before the court.
With these particular types of cases, it seems there are as many angles of legal. There are as many legal avenues that will be explored over the months and years as there are alleged genders to choose from. And almost
is that still growing, or have we reached peak
gender? Much like those who envision peak oil, it's never coming. There's never going to be a peak on this.
There's always more oil. There's always more genders.
Well, if you depending on what you believe, that's the gender is an identity, and everybody has an identity, and some people have more than one, and therefore there's at least 8 billion. And it's an argument.
I'm counting.
Hopefully, they're not all going to be made at the Supreme Court, and there will be at some point a clear, bright line ruling on what is and what isn't. Because I think what happens now is things aren't getting done. Everybody's too scared to go one way or the other on both sides of the argument, and there's a lot of activism on both sides of the argument. When what's really needed is this is the law of the land. This is how it should be applied. And for example, something like the Bruin decision, which came out, I think that was 2 years ago. The Bruin decision came out, and it broadly said things have to work towards fulfilling what the Second Amendment says. So anything that seems tangential, just stay away from it. Follow the ruling for the Second Amendment.
Right.
Follow what the Second Amendment is. And I think something like that is needed. Is something like that likely to occur? Not necessarily in this case, but on this topic.
Yeah, that is so speculative, Mark. I don't know what to say. I would say to you that Bruin guidance, that is how the court more typically operates in terms of it nudges rather than blocks in a more forceful way. And that's appropriate, meaning you don't want the court to be wildly swinging. You want it to be slow and steady because of so much of what it does impacts every area of our existence. That's part of the thing that conservatives and libertarians, kind of grouse about with the court, with everything being a court issue. Basically, you have one or two justices then controlling the republic in terms of what's legal, what's not, how we bank, what we can watch on TV, teach our kids, all this stuff. And Scalia, Scalia was great. One of the things that we don't have now much are the private thoughts of Supreme Court justices outside of the arguments and their opinions. And that wasn't always true. Justice Scalia would often appear on like PBS roundtables and stuff like that. You can see a lot of it on YouTube. But he always argued that, he was not a great arbiter of how Americans should, how the world should be, basically. It's like this should be decided by the elected representatives, not a couple people at the Supreme Court.
Well, it's funny you mention that because this isn't an ad, by the way, for anybody. We don't do ads on this, but there is the Daily Wire has something with Clarence Thomas out. It's either out now at time of recording or it's coming soon, about Clarence Thomas in his own words. And I believe the Free Press got quite a good interview with Justice Amy Coney-Barrett this last week. So we are seeing more outreach to the general public, which either could be a sign of the times or it could be in response to this NBC exclusive that we had.
The best revenge for a Supreme Court justice is just to say nothing and keep look at Clarence Thomas.
Yeah.
Who's got the best revenge? He never said a peep about it and just kept his mouth shut, and now he's living the dream.
He is the Terminator unleashed for his
laser eyes.
Judicial improvement. Judicial thought, I guess. We're going to be back with Scott after this short break. Don't go anywhere.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.